Thanks very much for having me. It's a pleasure to be with you today, and indeed, it's a pleasure to follow two excellent papers this morning by Rebecca and by Nick, which have really set the bar high, somewhat annoyingly. And what I'm going to do this afternoon is I'm going to look at the themes which we've looked at this morning, but from a different angle. And the angle I'm going to look at them is to highlight what is the problem. We heard this morning that the problem with marriage law is that it's complex and that it's antiquated. But that's true of most areas of law. And so why is it that the need for reform is so desperate? And I think that's particularly true because coming from the angle of the Church of England, it might appear that there's no pressing need for marriage reform. But yet, this afternoon, I'm going to argue that there are problems that need to be caused and that the current law is causing injustices. And I'm going to draw upon my forthcoming book, which the picture of which is on the slide in front of you, which will be published by Bristol University Press later this year in July. And the subtitle of that book, The Need for Reform, is what I'm going to be focusing on this afternoon. And indeed, if we now look at this next slide, it's quite clear that there's a range of statistics that show that there's been significant social change in relation to marriage and in relation to adult intimate relationships over the last 50 years or so since the enactment of the Marriage Act 1949. And these statistics are all from the ONS website. And what they show is that there has been a clear decline in the number of marriages. The marriage rate in 2017 has declined by 75% for men as opposed to 1972. It's now the lowest on record. And also what's notable from the statistics is that the number of religious marriages has declined. In 1900, there were about 85% of all marriages, whereas by the late 1970s, that was about 50%. Now, I say now, the most recent statistics of 2017, now it's only 22%. And civil marriages have outnumbered religious marriages every year since 1992. And the change which we discussed this morning, Rebecca discussed this morning, which allowed for marriage on authorised premises, brought about by Giles Brandreth, of all people. If we now look at the next slide, this also shows that the decline in marriage has been accompanied by a drastic increase in cohabitation. Those women who were non-married between 18 and 49 years of age, 1 in 10 of them were cohabiting in 1979. Now it's over a third. And if you look at couples living together between the age of 16 and 29-year-olds, that figure is 69% now of those couples are cohabiting. Now, some of those couples will obviously marry at some point, but nevertheless, what's clear is that a number of people are living as cohabitees. And what's also noticeable is that a number of those people think that they have the same rights that married couples have. Because the marriage law marriage myth, the idea that if you live with someone for an extended period of time, then you get the same rights as if you were married, that myth is still widely held. That myth is a complete fabrication, it's a complete lie, but nevertheless it's firmly held. And a British social attitude survey conducted in 2018 showed that almost half of those surveyed thought that common law marriage was a thing. And that's been backed up and analysed by research by Professor Anne Barlow and her colleagues at the University of Exeter. What that makes clear to me, and I'm by no means an expert in stats, what that makes clear to me is there's a number of different relationship types that now exist outside the Marriage Act 1949. And the one we've talked about so far is the number of cohabiting couples. This is the numerically the most significant. But there are also two other issues which have been picked up already in presentations today. One is what I'm going to call unregistered religious marriages, also sometimes known as religious-only marriages. These are situations where people have got married religiously, so they've got married according to a religious rite, but that hasn't conformed with the requirements of the Marriage Act 1949. And the second issue, which again we've seen raised this morning, is what I will call non-religious belief marriages. These are wedding ceremonies conducted by belief organisations such as Humanistic UK and also by independent celebrants, which again do not correspond with the Marriage Act 1949, meaning that if the couple want to get married legally and to get the legal perks of marriage, if I could put it like that, they need to also undergo a civil ceremony. So this afternoon, I'm going to focus on those two issues to show how they have become particularly problematic. So unregistered religious marriages and non-religious belief marriages. And these are slightly different issues. Well, they are different issues legally anyway. For non-religious marriages, there is a clear gap in the law. If you're a belief organisation, you cannot conduct a legally binding ceremony under the Marriage Act 1949. In relation to unregistered religious marriages, there is no gap. Now, a number of commentators and a number of official reports have talked about a gap and have said that Marriage Act only covers Church of England, Church in Wales, Quakers and Jews. That's not the case. Under the Marriage Act 1949, there are 4 categories of marriage: civil marriages, Quaker marriages, Jewish marriages. Well, there's 5 categories because there's also marriage according to Church of England and Church in Wales. And the final category of marriage is marriage in any place of worship, registered under the Place of Worship Registration Act and the Marriage Act. And this means that belief organisations simply cannot conduct lawfully binding marriages under the current law because they do not fit under any of those heads. Although they're different issues, it's the same effect. Ceremonies by religious groups or belief groups that do not correspond with the Marriage Act are not legally binding. And so if they want to legally recognize marriage, they then need a separate civil ceremony. And the problem comes on relationship breakdown, because if they haven't undergone that legal ceremony, they are in the same position as cohabitees, and so do not have the rights which a married couple would have on relationship breakdown. Now, I'm going to argue, contrary to quite a lot of the literature, that unregistered religious marriages is not necessarily a bad thing per se. There are reasons why people might want to enter into a religious marriage and might not want to enter into a marriage which is legally binding. My problem is with a situation where that is not an autonomous and free choice on the part of the parties, either because they're unaware of what the legal requirements are, or because the legal requirements prevent them from marrying in the way in which they want to. So what follows is going to be split into three unequal bits, chunks. I'm going to start by taking you through the problem of unregistered religious marriages. Then we'll move to non-religious belief marriages. And then finally, and somewhat briefly, we'll move to possible solutions. So let's begin with the problem of unregistered religious marriages. Now, there are all sorts of reasons why people would enter into a religious marriage and might decide not to enter into a legally binding marriage. And this is not just an issue in relation to Islam, although that has tended to be the situation that the literature has focused on in relation to unregistered marriages. And there's all sorts of reasons why people might not be complying with the Marriage Act 1949. The first reason might be that the law is unduly complex or restrictive. And this is a key reason because of the built-in requirement. And the empirical research which we've seen on this does suggest that for Muslims and for other religious groups, the requirement that if they are to marry, it needs to be in a place of worship, for it to be legally binding, is itself problematic. And so what we find is that the current law indirectly discriminates against certain religious groups, because it indirectly discriminates against religious groups who don't have a tradition of being married in a place of worship, perhaps don't have a place of worship, or have beliefs that marriage is a civil, non-religious, but still cultural event. So that's the first reason. The second reason is there may be a choice not to have a civil marriage, and this is often overlooked. And again, this is not exclusively in relation to Islam. The Law Commission's consultation paper mentions this applies for a number of religious and belief groups, that there may be a choice that actually the couple have decided deliberately just to enter into a religious marriage. And that might be, for instance, so that they can be together without being chaperoned. In such a situation, the religious marriage allows them effectively to date, putting then the legal obligations which would normally come with legal marriage onto such a couple, onto such a relationship, would be disproportionate. It might also result from an awareness that the religious marriage is not registered. And this does seem to be a major cause, that people simply do not understand the requirements of the Marriage Act. And that again could point towards reform of the law, in that the law should be accessible and is at the moment overly complicated for historical reasons, as explained in Rebecca's presentation earlier. But even if it doesn't require legal reform, it definitely requires education and increased awareness. Most problematically, it may not be a voluntary decision by one of the parties. It could be the fact that there's a power inequality in the relationship and one party wants to get legally married and another does not. It might be, but one of them is simply dragging their feet. Yes, we'll conduct the religious ceremony now, but we'll pop to the register office at some point, and then tomorrow never comes. Now, concern about unregistered religious marriages has been prevalent in the literature in recent years. It's been raised by several empirical studies. The Cardiff research, which I was part of with Professor Julian Douglas, Professor Norman Doe, Professor Sophie Gilliard-Ray, and Asma Khan, looked at a Sharia council at the Birmingham Central Mosque, and half the couples who were going to the Sharia council in order to resolve issues on relationship breakdown had not entered into a legal marriage. They'd only entered in to a religious one. And what we said then, and what I will continue to say now, is that that was problematic. Now, I've got no issue with systems of religious arbitration, with religious courts, religious tribunals, call them what you will, provided that they are an option, provided that they are a form of alternative dispute resolution. And the key word there is alternative. But what we found was that these women, and the litigants were women, it wasn't a form of alternative dispute resolution. Because they were not married in the eyes of civil law, they could not seek civil law remedies. They could either resolve disputes on relationship breakdown by themselves, or failing that, then the Sharia Council was their only option. And for the Cardiff researchers, this was problematic and questionable. and we call for education. Subsequent official reports have called for law reform and have highlighted that this is an issue. The Religion and Belief in British Public Life Commission, CORAB, highlighted it, as did the independent review into the application of Sharia law. It's also been highlighted by Baroness Cox in her private member's bill, the Marriage Act 1949 Amendment Bill, which seeks to deal with the issue of unregistered religious marriages by criminalising the celebrants. And this bill, which is currently before Parliament, it's not going anywhere, but it's currently before Parliament, seems to think that the magic solution is to penalise, fine celebrants. The first version was, the first time he introduced this, he seemed to think that the solution was to lock up celebrants. That now has been watered down to fining them. The proposed offence would penalise anyone who knowingly and willfully purports to solemnise a marriage. Now, I would argue and have argued in various different places and argue again in the book that this would do little to deal with the issue of unregistered religious marriages. It ignores the reasons why religious marriages might not be registered. In particular, it criminalises those who voluntarily enter into religious marriages, so to date. It also would criminalise humanist celebrants and independent celebrants who are carrying out weddings which are not legally binding. And the issue is not that celebrants are deliberately failing or colluding to register marriages. It's not that they're pretending that the marriages are legally binding. It's not that that doesn't seem to be the major issue. That's not to say that it isn't an issue in some cases, but it's not the major issue. The issue rather is that some couples are entering into religious-only marriages, either deliberately or accidentally, and that means they are then being denied the remedies which would be afforded to them had they entered into legal marriages. And if we look at the reasons for non-registration, which I looked at earlier, using the criminal law against rogue celebrants would do nothing in relation to all four of those things, and indeed has been interpreted as being an attack on the Muslim community, despite the fact that the draft legislation talks about celebrants generally. It's quite clear that the intention is that this is aimed at Islam. So Baroness Cox's proposal doesn't take us very far. The issue of unregistered marriages has also gone to court in the Akita and Khan litigation in recent years. This was a typical unregistered religious marriage case. They had entered into the nikah. The husband then said, oh, at some point we'll register it, and didn't get around to it, which may be so a difference in power relationships, or maybe simply benign. I mean, I'm using that excuse in terms of not tidying up the garage. So, you know, I think there needs to be a little bit of sort of leniency here in terms of the interpretation, but those are the facts of the case. At first instance, the judge used the law on validity. He put forward a very novel, flexible approach, and I'm using those words in inverted commas, which basically said that, oh, well, because there was an intention to enter into a legal marriage at some point, then this wasn't a non-marriage, this was a void marriage. And that distinction is important because a void marriage would give the couple the redress under civil law that a married couple would have on relationship breakdown, whereas a non-marriage would not. Ultimately, the Court of Appeal dismissed this as fanciful and as undermining the certainty of who was married and who wasn't, and so rejected it. But what's clear is that unregistered religious marriages continue to be a problem. And indeed,
It's there, it's not the main focus, but it's there in the Law Commission's work, which we've heard about this morning in the initial scoping paper, and also in the consultation paper published last September, both of which are excellent documents. The consultation paper was published as I was just starting work on the book. And the first couple of days, having read it, my initial reaction was horror, really, in that I was looking at this going, there's nothing for me to criticize. This is a very, very good report. It's a very, very thorough report. And it's also 500 words long, and I've got a very strict word limit to cover what I'm trying to do. But as we'll see, there are some issues with it, but generally, these are fantastic publications, as you would expect, given the quality of the presentations we've heard this morning. And I don't want to go through what they propose, but basically the move away from registered buildings to create this legal status of the officiant, which I think is possibly the strongest part of their proposals, would remove the parts of the law which are currently indirectly discriminate against certain religious groups, because suddenly you wouldn't then have to have a building. You'd have to meet other requirements instead, but this would allow the types of religious groups which at the moment are not using the Marriage Act because of its requirements to use the Marriage Act. So I think that if enacted, and I'm afraid I'm not going to cause huge controversy this afternoon because I'm basically a fan of what the Law Commission is proposing, and I you know, my major punchline is that their proposals should be enacted. If enacted, the Law Commission's proposals would, in my view, reduce the number of unregistered marriages. It would remove those which occur because of the strictness of the law, and it would remove some of those which occur because the couples are not aware of the requirements. Now, of course, there's still going to be some situations where the couple will still be, some couples may still be ignorant of what the new requirements are, but I would suggest that the fact that the new requirements are much more liberalized and lax because greater attention is being paid to the preliminaries rather than the focus of the ceremony and the requirements of the ceremony means that number would reduce. But there would still be some unregistered religious marriages. Now, as I said at the start, I don't think that's necessarily a bad thing. I think that one of the things we need to keep an eye on if we act in this area is that some unregistered religious marriages are not necessarily a bad thing per se. Those couples who enter into it freely, and it's an autonomous choice and it's an informed choice, I have no problem with it. But there still would be some unregistered marriages, unregistered religious marriages under the Law Commission's proposal, and this also, some of these, it would not be an autonomous and free choice. Those situations where one couple forces the other one to only enter into religious marriage. The Akita and Khan situation, where there is a vague intention to enter into, to go to the civil registrar to formalize the marriage at some point in the future, but tomorrow never comes. Those situations would still exist under what the Law Commission is proposing. What's the second problem? The second problem is that of non-religious belief marriages. And this comes from the firm distinction in the current law between religious and civil marriage. And as we heard from Rebecca this morning, the historical reasons for that might be questionable, but nevertheless, it's firmly entrenched in the current law. As is the idea that civil weddings need to be conducted by officers of the state. You can't have a civil wedding which is not in the presence of, I suppose, the celebrant can be someone else, but it nevertheless needs to be in the presence of superintendent, registrar, and registrar, and also the requirement that no religious service can be used. And what this means is that ceremonies solely conducted by belief organizations and independent celebrants are currently not legally binding. They do not have a legal effect, and so are currently outside marriage law. The reason for that is that the law as it currently stands still talks about a place of worship. And as we've seen in the Hodkin decision of the Supreme Court raised earlier, and there's a bracket missing there, before 2013, but as we see in the Hodkin decision, Lord Tolson there described religion as being spiritual or non-secular. So even under the Hodkin definition, religion does not go further than religious beliefs. That, of course, is contrary to other areas of law, most notably discrimination law, where non-religious beliefs are are protected on the same threshold as religious ones. It also looks suspect from the position of Article 9 of the European Convention on Human Rights. That's nevertheless the position under English law. And Lord Tolson held this was justified because for secular belief systems, there were other legal provisions which allowed for secular weddings to take place. But what he meant by this was civil ceremonies. And as belief organizations have argued, the type of wedding they want to conduct and the type of wedding which their adherents want is different from a civil ceremony. So simply go into the registrar, go into a place of approved premises, and having that civil ceremony will not suffice. And this was articulated by the all-party parliamentary humanist group in their report in 2018, who said that a humanist wedding differs from a civil wedding in that it is entirely handcrafted and reflective of the humanist beliefs and values of the couple. And indeed, the idea that at least humanist and possibly other forms of belief organizations should be able to conduct legally binding marriages has long been accepted in principle by successive governments. Under New Labour, there was talks of moving towards a celebrant system. In fact, this whole issue has been discussed quite a lot in the last since the 1949 Act. And Stephen Cretney's brilliant history of the family law in the 20th century looks at this issue quite a lot. It was looked at under New Labour, and they made noises that if they were going to change marriage law, humanism would definitely be included. And then nothing came of it because they couldn't find a bill, a suitable bill currently for Parliament to put those measures in. Private members' bills have also dealt with it. Lord Harrison's Marriage Approved Organisations Private Membership Bill in 2012 would have dealt with humanist marriages by comprehensive reform, including all religious and non-religious groups, provided that they were registered as a charity. They didn't have a place of worship and were of good repute. And what we saw during the parliamentary passage of the same-sex marriage legislation was a number of amendments which would have included, would have opened the doors to humanist marriages. So at committee stage, an identical amendment, Lord Harrison's Private Members Bill, was made. The then government rejected it because they said the good repute test would put too much pressure on the Registrar General. And they said this bill was not the right vehicle for reform. Then at report stage, the government seemed to indicate that they would welcome an amendment which would only cover humanism, because that wouldn't have the same issues as the initial amendment, only for the Attorney General, the then Attorney General Dominic Grieve, to argue that against that amendment on that protecting just one group would breach the European Convention on Human Rights. At committee stage then, when it was considered by the House of Lords, the amendment was widened again to include non-religious belief systems. And Baroness Stowell, speaking for the government, said, of course, everyone would support humanist marriages. But he said that it would require change in the law that would have implications which need to be thought through. So what you get for humanist marriages from at least 2012, if not before, is a series of almost wins, where humanist marriages are almost introduced, but not quite. And that's particularly true of what happened with the Married Same-Sex Couples Act of 2013. At report stage, an amendment to pass regulations within 6 months to allow non-religious belief marriages was rejected, but an amendment to hold a review and power to make provision to include humanists under the Marriage Act as a new category, very similar in design, it's thought, to how the Society of Friends are recognised by the Marriage Act, was included. So the Same-Sex Marriage Act included this obligation to hold a review and then a power to enact it, and also included a definition of belief organisation for these purposes, which was an organisation whose principal or sole purpose is the advancement of a system of non-religious beliefs which relate to morality or ethics. So this then led to a review by the Ministry of Justice, which came to the conclusion that the majority of those consulted, who responded to the consultation, were in favour of a League of the Law change, but they said that it would be difficult or impossible to apply certain types of criteria in terms of how you define belief without the risk of discriminating against some belief organisations. So it then said we need the Law Commission to carry out a scoping review to see what the ramifications would be, to see what needs to be changed in marriage law as a whole. You then get, in 2015, as we heard this morning, the Law Commission's scoping paper, which said there's a clear need for reform, but that there was no simple solution. And they said that rather than accommodating non-religious organisations by themselves, there was a need for a broader updating of the law on marriage. In other words, there was a need for a full Law Commission report. So that was in 2015. We then had to wait, we heard this morning, until 2019 for the announcement of that Law Commission project to give a full review of the law. That then produced a consultation paper in September 2020, on which we've heard quite a lot today, and the Law Commission is currently working on its full report due later this year. However, between the announcement of the Law Commission project and the publication of the consultation paper, there were a number of other developments. Rather than waiting for these comprehensive law reform proposals, humanist organisations sought immediate reform. They wanted the provision of the Same-Sex Marriage Act enacted by itself to allow them to start conducting legally binding ceremonies. And this was brought about by a number of private members' bills, some of which are still currently before Parliament, and again, are pretty much going nowhere, but also through litigation last summer. In the Harrison case. And in the Harrison case, a number of people couples who want to get married according to humanist ceremonies, or had entered into humanist ceremonies, alleged that the current non-recognition of humanist marriages breached their human rights in terms of it being discrimination on Article 9. Article 9 protects religion or belief, and the argument being that English law on marriage only protected religion, didn't protect non-religious beliefs. And, oh, that went too fast. The High Court last summer held that it was an interference with the applicant's human rights. But they held that it was justified by the fact that the law was currently under review by the Law Commission. It's a very interesting judgment to read, actually, because you don't think that's where it's going to go while you read it. When you read the judgment, it looks very much as if the humanists are really, really winning this case. It looks as if at the very least there'll be a declaration of incompatibility, and then at the end, the judgment doesn't go that far. But this does mean that if the proposals by the Law Commission or other proposals are not enacted to allow humanist marriages, then the continued non-recognition of humanist marriages would be a breach of Article 9. But of course would require further litigation. But this case and an earlier case in Northern Ireland would suggest that the outcome would be that the current law is discriminatory. And as I say, in the particular case, it was only justified by the fact the Law Commission were currently looking at it. The Law Commission, as we discussed this morning, has put forward a system which could include non-religious belief organisations. Their terms of reference doesn't require them, and in fact requires them not to look into whether they should be included. The terms of reference require them to create a system which could include them. This unfortunately means the Law Commission doesn't get into, because it can't get into, the issue of where the line should be drawn and the issue of whether or not non-religious belief organisations should be included. All they're doing, as hampered by their terms of reference, is presenting a scheme whereby non-religious belief systems could be included. So the category of officiants, which we saw this morning, it will include registration officers, the current public officials, Anglican clergy, nominated officiants who could be from any religion or belief body, and also as a separate category, independent officiants who could go straight to the General Register Office. The Law Commission put forward a proposed definition of non-religious belief organisation, which is parasitical on the Hodkin definition. Hodkin says that religious organisation is non-secular, so the Law Commission take that as meaning that a non-religious belief organisation would be secular. The problem with this is that not all belief organisations might be secular. Lord Tolson meant something rather specific by the term secular. He meant basically scientific. He says that in his judgment. And the other problem with using the Hodkin definition parasitically here is that this doesn't tell us a heck of a lot in terms of where we draw the line between belief systems. And the Law Commission consultation paper concedes this, because it then says that it would also need to be considered whether the definition of religion would need further filters. And indeed, for both religious and non-religious organisations, they propose 3 further requirements. That 20-member requirements, which was discussed this morning, which we heard the Law Commission is now reconsidering as part of looking at the consultation responses. And the trouble with the 20 membership thing is that it can either be too small or too big, depending on who you're talking to. Also, the requirement that the organisation should have a wedding service or sincerely held belief about marriage. And we saw some questions this morning on the chat, at least, questioning what would that mean in terms of sincerely held belief about marriage. And indeed, if they're conducting marriages, they're going to have some kind of wedding service, are they not? And also then the need to consider whether there's been express exclusion of those who are unlawful or contrary to public policy or morality, which also sounds as if it's going to be put in the Registrar General's office in the kind of position that the government in 2012 were keen to avoid of making those judgments. My main concern, apart from the fact that I think the definition as put forward doesn't work because it's overly broad and doesn't tell us anything, is that the definition of religious organization or belief organization falls apart for me the second you start recognizing independent celebrants and you allow them to apply individually. I'll take a step back to explain what I mean by that. This morning we hear that the Law Commission see very much their work as their schema rather, as being an efficient focused schema, focusing on this new office, this new legal office of the officiate. I disagree. I think what they're actually proposing is something that focuses on organizations, because all the requirements we've just seen are requirements on the organization from which the officiant would come from. So the Law Commission is actually making some detailed, albeit in my view, not particularly finessed, proposals as to what a religious or non-religious belief organization needs to do. Now, the problem with that is if you then also open the doors for individuals as independent officiants to conduct lawfully, legally binding marriages, there's a fundamental inconsistency, because you're placing greater requirements on those from religion or belief organizations because their organizations need to meet certain tests. Whereas your independent celebrants do not need to meet those tests. So to go back to that number of 20, for instance, if I'm an officiant who represents a belief organization, under the Law Commission's test, I would need to prove that there are 20 adherents. I could also register alternatively as an independent celebrant, and in that situation, I would not need to prove that I had 20 followers, 20 adherents. So my view is that the second you introduce that system of individual application for independent celebrants, then that category of religion or belief organization becomes problematic. You can't start limiting what you mean by religion or belief organization, because actually, once you allow independent celebrants in, there will be people conducting legally binding marriages who do not represent any organization at all. So I genuinely welcome, genuinely as well, welcome the Law Commission's move away from buildings. That's right, but I query the definition of belief. I think there's two ways ahead here. Either you employ a more rigorous definition of belief than the Law Commission is proposing, or you open up that third category of nominating organizations to all organizations. You don't say it has to be a religion organization or belief organization. Any organization can apply. Now that has the advantage of including a significant amount of independent celebrants, because a significant amount of independent celebrants belong to umbrella organizations. They are not purely independent. So if they became nominating organizations, the umbrella organizations, then you wouldn't need, or there would be less demand for and less use of a system of individual application. There are ways in which this can be done, which and samples, templates is the word I was looking for there. There are templates of how to do this in terms of a more rigorous definition of religion or belief. And in the book, a significant part of it is looking at comparative examples, because most of our neighbouring jurisdictions have modernised their marriage law in recent years. So the book looks at what has been done elsewhere. Of that, I think probably the most useful definition which could be used to define belief or define organisation, if we decide to open the door to any organisation, is the Irish Civil Registration Act, which has a very helpful definition of a secular body. Now, I'm not suggesting we use the term secular body. What I am suggesting is that we use or adapt their definition of secular body to define belief organisation or organisation. And the book looks at and applies and drafts what that could look at. I won't go through this in detail now, but basically it puts forward a definition of what's required, but also then excludes certain groups. So the exclusion of political bodies has proved controversial. So where you draw the line there is something which would need to be considered. So the options in relation to belief marriages, in relation to non-religious belief marriages, is either specific reform, and that seems to be what Humanities UK is looking for, and that can be achieved by private members' bills and further litigation, particularly if the Law Commission's proposals are not enacted. I would suspect that further litigation would follow, and given Harrison would likely to be successful if Parliament has rejected reform of this area. Or the second option is to go for general reform of marriage law via the Law Commission's proposal. And it's that second option which I think is the strongest, because if you go for specific reform, you will not deal with the issue of unregistered marriage. What I'm arguing is the Law Commission's proposals provide a way of dealing with, to some extent, both of these problems. So in terms of possible solutions, I said at the start the number of intimate adult relationship types now exists outside the Marriage Act 1949. Cohabiting couples, those who enter into religious-only marriages, those who enter into belief marriages. And of course, there's also the situation where people enter into these types of relationship and then later enter into marriage. So I'm not concerned with that. I'm concerned with a situation where people stay in these relationship types and it proves problematic on relationship breakdown or death. The Law Commission's consultation paper, for me, goes a considerable way to deal with these issues. It would mitigate, but not solve, the unregistered religious marriage issue by removing the built-in requirement, which would mean that indirect discrimination against certain forms of religion who don't have a build-in or don't have a practice or belief of religion, of marriages happening in a building would be removed. It would also, I think, reduce the number of accidental unregistered marriages. Wouldn't solve the issue, but would mitigate it. I think it would solve the issue of non-religious belief marriages with the kinds of revision which I've talked about in terms of either looking at that definition of belief a bit again to make it that bit more rigorous, or extending it to cover belief or to cover organisations generally. The Law Commission's proposals would do nothing for those who cohabit without any form of ceremony, but that's what you'd expect. A consultation paper on weddings law is not going to deal with couples who do not have any form of wedding ceremony whatsoever. The only way in which you could do that would be to have a very, very generous definition of validity of marriage or void marriage, but that would mean that the certainty of who is married and who isn't would be reduced. So the Law Commission's latest consultation paper is firmly welcomed by me. I say it's a stunning piece of work, comprehensive, detailed, and it would deal with all three, the first two of our three issues, and you wouldn't expect it to deal with the third. I think it needs to be teamed up with an earlier Law Commission proposal for opt-out cohabitation rights on separation. Now, the Law Commission is not the only ones to advocate this. There's been several private members' bills over years, and indeed, this is something else which has been enacted by neighbouring jurisdictions, Scotland and Ireland, to name just two. And this would not create a status similar to marriage for cohabiting couples. It would simply deal with the situation where people have been cohabiting, there's been some reliance between the two, and on relationship breakdown, there's a need to deal with that in a more nuanced way, which looks at the relationship rather than just looking at the property law question of who owns what. So the kind of opt-out cohabitation rights spoken about by the Law Commission would not recognise unregistered religious marriages, but it would provide a remedy for such couples on relationship breakdown. It would provide a remedy for the Akatar and Khan situation. Opt-out cohabitation would not recognise non-religious belief marriages, but again would provide a remedy if a couple had entered into a belief marriage and hadn't entered into a civil marriage and their relationship had broken down. And it would provide a remedy for the larger group, numerically larger group, who cohabit without any form of a ceremony. So that's the punchline which comes out of the book, really, is that what we need is both of those reforms. It offers a very warm welcome to the Law Commission's report. I know I've just criticised some of it, but there's 95% of it which I firmly agree with. Only what I've talked about is a very small portion of it. It welcomes that work, but says that we need to do more than that. And that's not a criticism of the Law Commission, because the Law Commission's terms of reference would not allow them to make these wider changes. And indeed, in the consultation paper, they do make that point. So, thank you very much. What I've argued is that a modernised marriage law, supported by limited cohabitation rights of separation, would provide redress for those three problems. And also that those three problems mean there is a need for reform. And like I say, that's developed in much more detail in the book. And if you order the book from the Bristol University Press website, you can see the advert. If you order it from their website, you get 20% off. And it's already fairly cheap for an academic book because it's quite short. So I think it's something like £36. And as Ruth already said at the start, there will be a webinar to discuss the book further, where there's a very, very esteemed panel of Baroness Hale, Professor Gillian Douglas, and Professor Jane Mayer, collectively huge names in relation to family law, who will be discussing what I've said. I'm happy now to discuss what I've said in questions. Thank you very much.
Brilliant. Thank you, Russell. That's an enormous amount of material that you've taken us through. And I hope you weren't too distracted by the very lively chat that's been going on in the chat box throughout. I've been desperately trying to keep on top of it to make sure that we can touch on as many issues as we can, but I fear that we may not get to all of them. We're almost at 3:30, but I think given the material that you've covered, Russell, we're going to focus on those a few questions from the chat box first, and then we'll throw it open to the wider panel discussion after those. Goodness me, the first point that a question that came up that I wanted to bring to your attention, Russell, is from Bill Bradford. It feels like a long time ago because it relates to Muslim marriages, which of course was at the very early part of your talk. Bill, I know that you have asked a number of questions, made a number of contributions to the chat, but you were asking Russell about the status of bigamous Muslim marriages in the context of the proposals that he has taken us through. Bill, can you put your question, please?
Yeah, it was just a case of part of the problem with the current situation was about the law being unduly complex or restrictive, in that some religious ceremonies couldn't be registered. And it was the point that actually if we're talking about a second, third or fourth Muslim marriage, for example, then it would be unlawful for that to be registered. It's not the law being unduly restrictive, it's the law applying its definition of what a marriage is as between two people exclusively.
Yeah, that's an excellent point. And I sort of made it clear. But what I'm talking about, and definitely what the Law Commission is talking about, is marriages which would meet the other legal requirements currently under the law. So yeah, what we're looking at is those first marriages, rather than anything in terms of bigamy. Yeah.
Thanks, Russell. I'm going to ask Olga Pierce to ask again, someone who's had a lively contribution to the chat box. But Olga, if I can ask you to put your question to Russell about the legitimacy of the concern of a lack of legal remedies where a religious marriage is a positive choice of the parties, as opposed to something inadvertent. And just to give her good notice, after that I'm going to ask Megan to ask her question about the role of the Charity Commission with Sharia councils. Olga.
Hi, Russell. Yes, my question related to the point where you stated that opting for a religious rite of some sort rather than legal marriage might be a deliberate choice. And I'm just saying that in that situation, can those who make the choice, and other people have commented that sometimes, for example, a woman under family pressure may not genuinely have the choice, but that's not what I'm worried about. What I'm worried about is, what I'm asking about rather, is when the choice is a genuine one. People know that legal marriage is an option, but they choose not to do it. They choose to go through a ceremony purely for religious purposes. Can there really be any genuine grievance that, should the relationship break down, they don't get the remedies that the law they opted not to use would have given them?
Absolutely, that's a great question. I think if I wasn't clear enough, apologies. What I'm saying, and hopefully this is clearer in the book, is that in those situations, there shouldn't be any remedy under state law. If parties are deliberately and voluntarily and autonomously deciding to enter into a religious-only marriage, then they shouldn't be entitled to remedies which couples who are entering into a legal marriage would be entitled to. I think I made the point, but in a reverse way, because a number of other reform proposals, not the Law Commission, but other reform proposals, has sought to deal with all religious marriages, and has put forward things similar to what a number of continental jurisdictions have, of saying religious-only marriages should be illegal. Now, my view is they should be unlawful, but not illegal. They should have no legal effect, but people should still be able to enter into them, so that, for instance, people can, in certain communities, can date without being chaperoned. The point I'm making, or at least the point I'm trying to make, is that where the law should step in is where that's not an autonomous choice by the parties, where either they're forced into it because the law is overly restrictive, or because it's a mistake, because the law is overly complicated, or the situation which you highlighted, where there's been unequal power between the couple. And I think that in that situation, yeah, the law can take a role through the type of opt-out cohabitation rights, which I hinted at the end of the presentation.
Thank you.
Thank you, Russell. Megan, if we can deal with your question about the role of the Charity Commission in relation to Sharia councils, and then we will move on to our broader panel discussion and draw the others in. In fact, there are issues which have been raised in relation to this paper that I'm sure the others would like to comment on. Megan.
Thank you very much, and thank you very much to Russell for a really interesting talk with lots of points I agree with. So what makes nikah different from, say, humanist marriages, non-registered marriages, pagan non-registered marriages, these ceremonial ones, is that they are registered and sort of processed in a way that looks a little bit like a parallel legal system. There's quite a formality to them, which the Sharia councils play a significant role in. And what happens, the problem arises with these Sharia councils. One of the many problems that arises is the way that disputes regarding nikah are managed. And it's been said many times that often Sharia councils, they rule on disputes in a way that is unfair to women, that there are different standards for men and women in these councils, that the councils are generally arbitrated mainly by men. But these councils generally operate as part of mosques and similar centres, and these are very often registered charities, so they come under the restriction of the Charity Commission. So my question is whether the Charity Commission needs to play a more active role here, because if a charity is basically funding activity that is treating women unfairly, so that would go against the Equality Act, or is otherwise causing some sort of societal or individual harm, that would be going against the public benefit requirement. So is there more that the Charity Commission can do here to ensure that where unregistered religious marriages happen, that if the disputes occur, that they are managed in a way that is much fairer to the parties involved?
Well, the short answer to that is yes. The slightly longer answer to that is that one of the things which came out of the independent review of Sharia, which the government didn't support, so supported the idea that we need to look at whether there needs to be criminal offences, because, you know, locking up celebrants is a good way forward. One of the things they didn't support was the idea that there needed to be more regulation of Sharia councils. And the government's argument there, and I suppose I should put the word argument in inverted commas, was that that would run the risk of endowing upon them more respectability. And for me, that fundamentally misses the point, because the government, if they want to, can pretend that these Sharia councils don't exist. They can pretend they're not influential on the communities which use them, but they are. So surely the way ahead is to look at requirements and to look at regulation that doesn't single them out in ways which also would be discriminatory, but which would ensure, or at least try to ensure, that the kind of safeguards you've spoken about are there. So, you know, this is a wider topic, the topic which I'm looking at, but, you know, there is still a case for regulation. I mean, the main problem is we still do not know a great deal about how they operate. There has been numerous empirical studies over the last, I was going to say decade, but probably 15 years now, which are focused on the most mainstream Sharia councils, ones who are willing to talk to researchers. And then our researchers have reported what they've told them. But we've got no idea how many Sharia councils there are, The more informal they are, the less likely we are to know. And also, let's remember, this is not simply a Muslim issue. We've got no idea about religious arbitration generally. It's quite possible that next door to me now, as we speak, there may be some form of religious arbitration in a way that looks like nothing like a court taking place, but nevertheless produces a judgment which the parties will interpret as being binding, and which may well discriminate and have those shortcomings which you've highlighted. So this is a major, major issue on which further research is needed, and different research is needed.
Thank you.
Thank you, Russell. And thank you not just for that answer, but for your contribution this afternoon, for sharing your experience and expertise and enthusiasm with us.